Protecting Public Health in Developing Countries, the 2001 Doha Protocol. The 2001 Doha Protocol refers to the Ministerial Declaration on the Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS, and Public Health. This declaration was adopted by the Fourth World Trade Organization Ministerial Conference at Doha, Qatar on 14 November 2001. The Doha Protocol came about in response to concerns over the existing TRIPS framework and emerging intellectual property issues. The TRIPS agreement, concluded in 1993, had created comprehensive new rules to protect intellectual property, develop standards on the use of patent enforcement, and govern disputes. However, of particular concern at Doha were the significant changes to the standards of IP protection that TRIPS had demanded. All countries were to develop strict patent protection laws which posed problems for developing nations. TRIPS attempted to balance the desire of the West to protect patents and the right to health of those in developing nations by enabling countries to avoid certain intellectual property rules and take measures such as parallel importing and compulsory licensing that promote the production of generics, in turn enabling access to affordable medicines. In practice, however, the right to make use of these flexibilities by developing nations was being challenged, legally and politically, by multinational pharmaceutical companies and governments of developed countries. For example, in 1997, the South African government amended legislation in order to promote the availability of affordable HIV/AIDS-related medicines using compulsory licensing and parallel importing under the TRIPS agreement. Following this amendment, 39 pharmaceutical companies took the South African government to the High Court, arguing the amendments were in conflict with the provisions of Article 27 of the TRIPS agreement and therefore in conflict with the Constitution. The Doha Declaration sought to address this tension in interest between the North and South on the topic of patented pharmaceuticals. It contains 7 paragraphs and it is as a subsequent agreement between parties regarding the interpretation of the TRIPS agreement. Article 31.3a of the Vienna Convention states that we should consider the protocol alongside the original TRIPS agreement. The first 3 paragraphs of the Doha Declaration outline the primary concerns of both developed and developing nations, including public health problems and the importance of intellectual property protection in the development of new medicines. The 4th paragraph of the Declaration highlights the balance that the Doha Protocol attempts to strike by affirming that the TRIPS agreement can and should be interpreted and implemented in a manner supportive of WTO members' rights to public health and, in particular, to promote access to medicines for all. Paragraphs 4 and 5 should be read together to provide guidelines for countries seeking to rely on the flexibilities in TRIPS to pursue public health goals. Paragraph 5 highlighted that countries have the right to determine what constitutes a national emergency of health, may determine their own exhaustion regime, and grant compulsory licenses. These flexibilities provide developing countries with methods of accessing more affordable medicines. Paragraph 6 of the Declaration recognised that countries without pharmaceutical manufacturing capacity could not exercise the TRIPS flexibilities. For instance, in order to benefit from compulsory licensing regime, countries must have the capacity to manufacture pharmaceuticals. Paragraph 6 continued on to urge the TRIPS Council to find an expeditious solution to this problem. Finally, paragraph 7 extended the time frame that the least developed countries have to comply with the TRIPS agreement by an extra 10 years until 1st of January 2016. So has the Doha Declaration been successful? Many have praised the Doha Protocol's affirmation of the flexibilities within TRIPS that promote public health. The protocol is also an excellent tool for interpreting the TRIPS agreement and has been expressly referred to in treaty provisions following its adoption. Several countries have benefited from these flexibilities, including Cambodia, who was excluded from patent protection laws until 2016, and the African nations of Cameroon and Malawi, who've both authorised the importation of generic versions of patented HIV/AIDS medication to the benefit of their citizens. However, issues with the TRIPS agreement and its impact on public health still remain, despite the Doha Declaration. The USA continues to place countries that do not meet its strict IP patent standards on watch lists and may enforce trade sanctions against those nations. Countries who wish to engage in trade may also be subject to bilateral or regional trade agreements that do not contain the flexibilities within TRIPS. Overall, though, since the adoption of the Doha Declaration, the use of TRIPS flexibilities for public health has never been challenged by developed countries before the WTO dispute settlement body. I therefore conclude that the Doha Declaration on TRIPS and public health has ultimately proved to be beneficial for developing nations in promoting public health and access to medicines for their citizens.